with this agent yesterday. She's like, the number of agents who aren't taking the time to really understand the market and the data.
That's why I say it's such a
they're
good market.
doing no service.
That's why it's such a cool market. That's what I keep trying to get across to people is this market is awesome because you guys are going to be those agents that are informed and can guide.
It's just getting the average consumer to trust you.
It's a process. Don't think it's going to happen immediately because everything they're hearing is not what you're telling them. So their initial reaction is what? You're just telling me that because you want a sale or a commission. So there's a process to gaining trust.
Right.
Right? When you talk about trust, it's a combination of time and knowledge, basically, right? We talk about that a lot in leadership training because of the trust that you guys need to have in us to know that we're not BSing you on stuff.
Right.
I mean, we only do that like 50% of the time. The other 50%, we're like basing it on facts.
Yeah. Okay.
Let's get started. I know people start rolling in late, but I don't want to, anybody that's watching, I don't want to hold up. So, all right, so today we're going to talk about seller financing addendum. And, where's my cursor here? What I want, the reason why, come on. Jeez. All right. Well, the reason why I wanted to talk about this today is because a couple of things. One is, over the last 9 or 10 years, we've seen continued appreciation of home prices, right, which results in a lot of equity, right? So the sellers have a lot of extra equity in their home, especially over the last 2 or 3 years. We've seen as much as 20 to 40% increase. They're controlling it, I think. Okay, sorry guys. And then the second reason is we were just talking before the class, shifting market a little bit. Things are maybe sitting longer, and sellers are more willing to come up with creative ways to get the home sold. We talked about the lease option a couple weeks ago, or the option agreement. And one of these other ways, perhaps, is to carry back financing. So what is seller financing? Does anybody want to just summarize it for me, like I tried to get you guys to summarize last week or 2 weeks ago? Anybody want to try to? What is seller financing? Anybody want to give it a shot? Everybody's just staring at their document right now. Now I know how teachers feel.
The seller's going to carry
Here, Rayanne, here.
back a loan.
Just because people are watching.
The seller's going to carry a loan for the buyer.
Right, so they're going to sell the home and then become the what?
The finance.
The
They'll
lender.
be
They're going to become a lender.
Now,
Correct.
do they fall into second place?
Well, so we're going to talk about that. So that question, Rayanne, was do they fall into second place? And what you mean by that is, are they a junior lien holder, a lien holder that's maybe in second position behind a senior lien or a first lien? They could be, and we're going to talk about that because the form addresses it. All right, so let's hop right into the form. So obviously I've highlighted a number of red items. I'm going to go through most of these provisions. I'm not going to go through every provision because some of them are just rarely come into play here. So first of all, this is an addendum. So if we are drafting this seller financing portion, it can be an addendum to the RPA with the purchase agreement, or it can be an addendum to a counteroffer coming back from the seller, right, or a buyer counteroffer. So it actually is an addendum to our contract. These terms are going to get incorporated and they're going to go to escrow. Okay, so it's not just a side agreement, or it's not just a note that the buyer and seller are putting together a separate and apart from the RPA. It's going to be a part of our agreement. Okay, so let's dive right into paragraph 1. Okay, this is kind of really the meat of it if you think about the terms of the note. So principal, interest, payment, and maturity terms. So we're going to have to fill out the principal amount, okay, that the buyer is going to be paying the seller. All right, we're going to come up with an interest rate, and that interest I highlighted per annum. It's per year. All right, we're not talking, even if it's a a short-term 1-year loan, we're not talking monthly interest or anything. It's interest at a percentage, a certain percentage per year. And then payable at approximately blank dollars per month or year or other. So you're going to come up with the principal amount of the loan. Okay, so let's just say it's $100,000 that the seller is going to carry back. $100,000 loan, interest at 5%. That's going to result in a payment at approximately blank dollars per month. Okay. And then remaining principal balance due in blank years. So let's stop there for a second. You can structure this any way you want. So if you want it to be P&I, principal and interest, it could be principal and interest. It could be an interest-only loan, in which case the monthly payment's just going to come out to the same amount of the interest-only payment. All right? It can be structured in different ways. It can be structured with a balloon payment, which we'll talk about, where maybe it's a $100,000 loan, but you're amortizing it over 30 years, but it's due in 5 years. Okay, so there's going to be a balloon payment on the 5th year. So you can structure it any different number of ways. All right. The key is just that obviously if we're being a little creative, that everybody understands what the end result is going to be. All right. So in parentheses, note an interest rate of 0 or other rate below the applicable federal rate may trigger a tax on the seller for the amount of interest that would have been received if the minimum applicable federal rate was charged. So what does that mean? Anybody want to just guess, summarize that real quickly? What does that mean?
Basically, they're saying that's you're giving a gift, or you're not. That's income you're entitled to that you're volunteering.
Yeah. So first, you have to charge interest. And what Rich just said is, if you don't charge interest, the IRS looks at it like a gift, right? So they're going to impute that interest to the seller, the lender here, okay, as income. The applicable federal rate is the minimum. And they don't say a number because it changes. Okay, and you can just look that up. Yeah, Rich?
Can I screw with you for a second on this?
I don't know, can you?
Every year you're allowed $10,000 in gift money.
Oh, dude, you're killing me. I already know where you're going with this, too.
Every year you're allowed $10,000 to give to an individual.
Yeah,
so
I think it's more than that, but yeah.
Well, whatever the hell it is now. So can you apply that towards that?
So okay, I don't want to get into a ton of tax advice, but here's something that I've seen people do, and I've done it myself, actually. So let's say, and this is different because it's not seller financing, but let's just say mom and dad give kids a gift of $100,000 to help buy a house. One thing you can do is part of that note, because you do have to have a note because it's a loan or it's a gift of $100,000. Let's say you tie that note, that $100,000 with a note, and then every year it's due in instead of a monthly repayment amount, let's say it's a yearly repayment amount of $15,000 a year. I'm just picking a number. Instead of mom and dad collecting that, they forgive it as a gift. So they burn it off over a period of time, and that's basically what you're saying, Rich. Don't do that unless you're talking to your CPA and getting some tax advice. But there are ways to burn that off as a gift, okay? So, but let's just, generally, Olga, there's the forms right back there too. Generally, you cannot charge 0% interest, okay? Or otherwise, that interest has to go somewhere because the IRS says there's got to be a certain minimum interest amount, and that's the God, I'm going to say that right, applicable federal rate. Okay, so that's what that little note says. That didn't used to be in this form. That was actually added recently. Okay, so you always got to have some interest. Even if the AFR is 2.5%, charge 2.5%. If you're really not trying to charge a lot of interest. Okay, there's some other potential tax advantages too. If a seller is not taking those proceeds right in this year, but instead taking them as loan proceeds over time, so there's ways that this comes into play, but if the seller wants to get really creative, they need to talk to their CPA. Okay, but just generally, if we're just structuring this, you could structure it as principal and interest, or you can just structure it as interest only.
What are the main situations where this would come up?
Seller financing?
Yeah.
One is usually a ton of equity and or completely paid off, right? Maybe the buyer just needs a little bit of extra money to bridge the gap. They don't have all the down payment or something of that nature.
You can pair this up with a regular loan.
Yes, you can. Yeah,
okay.
yeah. And so when Kevin,
short 100,000, like
you can,
it's
don't have
down payment.
Yep, you can cover the difference. Now, in that case, we'll talk about you may be in a junior position as the seller, not in a senior position. But if some of you that were here when Kevin Shoup did his 3-2-1 buy down, that was a question I asked. Hey, how does it work with seller finance? And he said, yeah, as long as it's within the guidelines, it's not going to affect their ability to qualify for the first.
Yeah, but you're in a slippery slope there, because where are you if they don't qualify, but the seller is willing to carry whatever they don't qualify for? Do you disclose that to the lender, or does that then become a silent second?
Yeah, you would need to disclose that to the lender. Yeah, you'd have to disclose that to the lender.
Yeah, but then the lender may
Additional
not
debt.
make the loan if they know that they're going to be over their ratios.
Yeah, I mean, they'd still have to fall within the guidelines of the first. That's what I'm saying. more often than not, it's the way I've seen it anyways over the last 15 years has been where maybe they have the income, they have they're a solid borrower, but maybe there's other issues where they can't qualify, or maybe it's a unique property where it's going to be hard to qualify for conventional financing, and the seller's got a ton of equity. Like maybe it's a $1.5 million property and they got $1.3 million in equity, so they're going to pay off their loan and then carry back $700,000, $800,000, $900,000 because that loan to value there is 60-70%, so they're very well secured and they're in first position. So we'll talk about that as we go through, like what does that look like if the buyer / borrower defaults, because all of that is covered in here. But that's where we see it. We don't typically see it on just everyday residential transaction where the seller's like, oh yeah, let me give you some money that I don't want to take as proceeds, Usually it's a little bit of a unique property, ton of equity, that's where we see it. And occasionally we have seen them where the seller will carry back in second position, but more often than not, they're going to be the only loan and be in first position, okay? So paragraph 2, loan application credit report. So within 5 days after acceptance, A, buyer shall provide seller a completed loan application on a form acceptable to seller, such as the Uniform Residential Loan Application, and B, authorize the seller and or agent to obtain at buyer's expense a copy of buyer's credit report. So in other words, you got to provide a loan application so that the seller can take a look at it and evaluate whether or not they want to lend you that money, okay? And it authorizes the seller to go ahead and pull their credit report, okay? Paragraph 3, credit documents. This extension of credit by seller will be evidenced by, and I highlighted note and deed of trust. That is the most common way we see it. So just like in an everyday transaction where the buyer with their new loan is going to get a note and deed of trust, right? The deed of trust is the document that gets recorded in the chain of title, but they also have that note with their lender. That is why I highlighted that one. We don't really see a lot of all-inclusive note and deed of trust. That's the AITD. When we were talking about the option agreements, I think JP asked me about that. We're not seeing a lot of that. You just tend to see the standard just promissory note, deed of trust, okay? And when I started today, I said, hey, this is a part of the agreement. Escrow is going to get this, and escrow is going to draft that note and deed of trust for you, okay? It's usually a pretty straightforward sort of note and deed of trust. The note obviously goes, the note goes to the parties, the deed of trust gets recorded, right? That's what's evidencing the loan, okay? Any questions there? Okay. So that's kind of like the meat. Okay, here are the terms, here's the credit. We're going to evidence all of this with a note and deed of trust, okay? So then everything below that, you're going to check the box only if it's going to apply here, okay? And I'll go through the ones that usually do apply, okay? So again, the following terms apply only if checked, okay? Paragraph 4, pretty self-explanatory, late charge, okay? If any payment is not made within blank days after it's due, a late charge of either blank dollars or percentage may be charged to the buyer. Again, pretty normal. That's what we see in an everyday loan. Typically, it's after the 15th day, but you can, in seller financing, it could be 5 days, 10 days, whatever you want it to be. But there are limits on residential 1 to 4 on the late charges. So in red there, it says on single-family residences that buyer intends to occupy, California Civil Code Section 2954.4A limits the late charge to no more than 6%, okay, of the total installment, and a grace period of no less than 10 days. So if you're kind of thinking about like the 15 days that we see with most conventional financing, that's consistent with that Civil Code section, and it can't be more than 6%. Okay, if we're dealing with like commercial property and things, we can vary that a little bit. But if we're dealing with our standard residential purchases, we're going to be capped at 6%. All right. Paragraph 5, balloon payment. Did I get control of this back? I thought somebody had it, but no. All right. Paragraph 5, balloon payment. So there we go. Okay, they got it. The extension of credit will provide for a balloon payment in the amount of blank dollars plus any accrued interest which is due on blank. Okay, so again, if you're not, let's say you're amortizing it for purposes of figuring out your payment over 15 or 30 years, but it's actually going to be due in 5, then you're going to have a large portion of that loan that's not due in 5 years because you've amortized it over 15, 20, 30 years, whatever it is. So there's going to be a balloon payment, and you're going to have to figure that out. usually by looking at like an amortization calculator, and you're going to know, okay, at the end of year 5, I'm just picking a number, the amount is going to, there's a balloon payment amount that's going to be due. Okay, and so you're going to put that amount in there, and you're going to put in the date on which it's due, and you'll see when the note and deed of trust are drawn up, the deed of trust is going to contain some very specific language and the note, so that it's clear there's a balloon payment. Okay, and escrow is capable of doing that for us. We've had them do it before. All right, so that's the balloon payment issue, and that's not uncommon to see a balloon payment. What did I screw it up, Ty?
Is the mouse fine?
It's not reacting.
Good.
Okay, so that's the balloon payment. Prepayment. We've all heard of prepayment penalties, right? So you have the option to include a prepayment penalty here. If all or part of this extension of credit is paid early, seller may charge a prepayment penalty as follows. So where do you think we've seen that before? I mean, because it's not real common nowadays that we're seeing prepayment penalties in conventional financing, right? In which scenario may that come up where the seller says, I do want a prepayment penalty? Because more often than not, they don't, okay, in my experience. But where might that come up? Where would they want a prepayment penalty? Any guesses? So I'll tell you one scenario that I've had recently where it came up. The buyer, and this was it wasn't single family, I believe it was commercial. The buyer said, hey, I'll pay you a little bit of extra money if you carry back the financing for me, a certain amount of financing. So I'll actually pay you more than what you're asking for, or maybe what I would pay if you just took all the proceeds. And the seller said, great, I'll take more, but if you pay that off, early or something like that, then I'm not going to get as much of that interest over time, so you're not really paying me that amount of money. Does that make sense? Like, okay, yeah, you induced me to give you some financing over 3 years, but I would have accrued X number of dollars in interest over 3 years to that difference of what you're paying me, and if you pay it off in 6 months, I don't get that interest. So the seller's like, well, if you pay it off within this time period, I want this amount of money as a prepayment penalty, and then we staggered it over time. So yeah, to offset it, exactly, because they wouldn't otherwise be getting that interest over time. So that would be like an example, and the seller was fairly savvy and said, had kind of developed it, and it was a commercial property, so there are prepayment limitations with residential, and we weren't necessarily tied to those with this property. So that's like one example. Thanks, Ty.
Mike, don't go in there. I didn't think you could avoid a prepayment penalty on a residential property.
Sorry. Am I missing something? What?
I did not think you were, I thought it was illegal not to, actually, I thought it was illegal to have a prepayment penalty on a residential. Commercial, absolutely, but residential.
No, we used to have prepayment penalties all the time on financing, yeah. It's not illegal, there's strict limitations to it and strict amounts. It's not illegal, it's governed by statute, okay? Commercial, you have more leeway. Residential, it's absolutely, it's very, very regulated, just like almost all of our stuff in residential, right? Okay, next one, due on sale. Due on sale clause, this is paragraph 7. A due on sale clause is in just about every single one of our deeds of trust, okay? So if any interest in the property is sold or otherwise transferred, seller has the option to require immediate payment of the entire unpaid principal balance plus any accrued interest, okay? So what does that mean? It means that if it's a 5-year loan, and the buyer turns around and resells the property in 3 years or just transfers it, then the seller has the right to say, okay, my entire loan is now due. Simple as that, right?
So when you say transfer it.
Ty, what's wrong?
Is it still not working?
No. Go ahead, Dorinda.
So when you say transfer it, could that be
Ty, it looked like there was a delay on it.
any type
did
of a
it and then it would
transfer?
show up later.
On
Any
the-
type of, yeah, any type of a transfer. Other than because of just, other than like transferred into your trust or something like that, yeah. Not like that. You'll see there's certain provisions in this, because all these deeds or trusts are standard, okay? So they all have the same provisions. Transferred into your trust or like a wholly owned LLC or something like that is not going to trigger the due on sale typically. But if you transfer it from you to, and this is why subject to financing is a problem. When you transfer from you to Rayanne, and Rayanne doesn't get new financing, just starts paying me as the lender, and then I find out about it, I could have a right to call the note due. That's that due on sale clause. So that's the risk of subject to financing, right? When you buy a property and you take subject to the existing financing, is there's a due on sale clause. Okay, so let's just recap those 4. We're usually going to check box 4. We may check box 5 if there is a balloon payment. We typically are not seeing box 6 checked because we're not seeing a prepayment. 7 is always checked. Okay, you always are going to have a due on sale. All right, so just to recap those 4. All right, now paragraph, Caesar.
So if they were to sell the property, can they still continue paying that loan?
So,
I don't know if that was after their year.
so like subject to financing, let's say that, and this happens, right? So let's say Dorinda, or let's say you have a property and you sell it to Rayanne, but you don't pay me off as the lender, and Rayanne just keeps paying me.
Yeah.
I'm not as a lender unless somebody is telling me. Typically, they're not just checking title, right? So as long as Rayanne is still paying me, I have really no reason to believe that there's been a transfer or necessarily care there's been a transfer. That's the subject to. Now, if she then goes and refis at some point down the road and pays me off, then I'm paid off. But if I find out about that transfer for one reason or another, maybe she misses a payment, we look into it, and I see that title has been transferred, I have the right to immediately call it due. Okay?
Who would you call it due from? The original buyer?
The original buyer is still the borrower. Okay, but your interest now in the property is being affected because you're the owner. So you are going to be probably trying to figure out a way to get me paid off if you can, or otherwise I have a right to foreclose. And even though you're not the borrower, it's still going to affect your interest in the property. It's not that it's not a clean title. It's just that that doesn't really necessarily play a role. So I'm going to foreclose, and my interest is I can only go after the property. We're going to talk about that because there's no recourse on these loans. So my only recourse is the property. These are non-recourse finance loans.
Does she have any way of knowing that there's an additional loan?
She as the new owner? There's no additional loan. I'm going to table that discussion for a moment just because we're going to get into the whole subject too and what that looks like. But we are going to talk a little bit about that process of finding out, right, in these following paragraphs. Okay, so let's look at number 8. And this is going to partly answer the question. Request for copy of notice of default. You'll see a little asterisk there. And if you go down to the bottom, it says for paragraphs 8 through 10, in order to receive timely and continued notification, seller is advised to record appropriate notices and or to notify appropriate parties of any change in seller's address. Okay. So let's talk about paragraph 8, request for copy of notice of default. The notice of default is the first step in what we would call the foreclosure process or the trustee's sale process, right? And it says only applicable if seller is financing a loan secured by a second or junior lien. Why would that be the case? So reread that, request for copy of notice of default. Only applicable if seller is financing a loan secured by a second or junior lien. If you're the first lien holder, you're going to be the party filing the notice of default. So you don't need notice from anybody because you're the party filing it. Now, if you're the second lien holder or junior lien holder, and the first records a notice of default, you don't automatically get notice of that as the second lien holder. Okay? So if you are a seller financing second lien holder, and now your borrower / buyer is in default under the first, that's going to have potentially a direct impact on your interest as a second lien holder, right? Because if that first forecloses and there's not enough money to pay you, you get wiped out and don't get paid. Okay, it's sometimes called a sold out junior, okay? Because you get paid in order of priority. All right, so in order to protect your interest, you would want to record this request for a copy of notice of default so that if the first files a notice or records a notice of default, you're going to get notice. You're at least going to have an opportunity to perhaps protect your interest. Okay?
Mike, going back to that first, the due on sale,
Yeah.
why is this lacking, or why is there not a notification to the seller or the note holder that it says here, what the hell is it? Seller has the option to require immediate payment of the entire unpaid principal or balance. So it's been transferred. How come there's not a protection and then there says upon transfer of the property, the lien holder will be notified? I mean, that doesn't make sense not to have that notification in there.
I don't know. Well, there's no mechanism for that other than it's already in the deed of trust that says you're not supposed to transfer the property, but people are doing it, right? Like subject to financing we're talking about. Okay? There's no mechanism for it though. There's no trigger or anything, because who has to comply with that? Who would have to comply in real life with notifying the lender?
The seller.
The seller who's trying to avoid notifying the lender. So you know what I'm saying? There's no actual real practical trigger, because if the party that's obligated to notify the lender is the party that's trying to transfer without notifying the lender, they're not going to notify the lender.
So that's technically a fraudulent conveyance.
It's not a fraudulent conveyance. It's not. No. It's not fraudulent. That fraudulent conveyance is a completely separate theory under the law. Okay. It's a conveyance that maybe is in breach of the deed of trust, but it's not fraudulent in that sense. Fraudulent conveyance has very specific meanings under the law. Okay. But again, if the lender finds out, they can say, boom, I want the entire loan now due, and if you don't pay me, you're in default, and I then have the ability to do the foreclosure action. So there are real world repercussions, but there's not a mechanism that I'm aware of anyways that would allow the lender to just know about it, unless they have something set up internally that would trigger them somehow. Because the mechanism like this request for a copy of notice of default, that's something that can get recorded, and then the first lender is obligated to send them the notice to the junior lien holder. Here, again, the party that would be triggering it would be the seller who's trying not to notify the lender in the first place, or the buyer, okay? And we see subject to, I mean, we just...
I'll scroll for you.
Okay, thanks, Ty. So we are on, so that was paragraph 8, request for a copy of notice of default. Paragraph 9, request for notice of delinquency. So again, only applicable if seller is financing a loan secured by his second or junior lien. Statutory request for notice of delinquency is only valid for 5 years, but may be renewed. A request for notice of delinquency is defined in California Civil Code section 294E to be signed, recorded, and sent to senior lien holders, and recording and statutory lien holder fees paid for by buyer. Seller will be made to senior lien holders. If not, seller is advised to consider making a request for notice of delinquency. Seller is advised to check with senior lien holders to verify whether or not they will honor this request. So same sort of thing. We're going to file this request for notice of delinquency to know that if there's any delinquency in payment of taxes or anything else, we're going to find out about it, okay? Again, if you're a senior lien holder, if you are the only lien on the property, if you're in first position, don't even have to worry about 8 through 10. Okay? Don't even have to worry about it, because you're going to be the one that is filing or recording the NOD. Okay? Tax service, paragraph 10. If a property taxes on the property become delinquent, tax service will be arranged to report to seller. Again, so now we're talking about property taxes. There's third-party companies out there that basically can give you notification of these things. Okay? So we're talking about property tax services. Property tax services property taxes are always senior, but you can have a service that will notify you, okay, that hey, they've stopped paying their property taxes. All right, so 8, 9, and 10, just to recap, only at issue if there's a junior lien holder, if the seller is a junior lien holder. Okay? So let's go to paragraph 11, title insurance. Title insurance coverage will be provided to both seller and buyer, ensuring their respective interests in the property. If not, buyer and seller are advised to consider securing such title insurance coverage. So we're going to have the owner's policy. We're going to have the lender's policy in every deal. We know that, right? This is saying, is title insurance going to be provided specifically for the seller financing? Always recommend title insurance, always, okay? There's no reason not to have it. The policy is not that expensive when you have an owner's policy. And if they're the only lien holder, we need title insurance. Hazard insurance, okay? The party's escrow holder or insurance carrier will be directed to include a loss payee endorsement, adding seller to the property insurance policy, okay? So hazard insurance under paragraph 12, we are always checking that box too. We want our seller as the lender to be added as a loss payee under the homeowner's policy, okay? To protect, again, this is all to protect their interest in the property, all right? Let's skip paragraph 13 because it doesn't really come into play very often. Let's turn the page, okay? Paragraph 14 talks about negative amortization, deferred interest. We don't see this very often. We don't see this very often with seller financing, just because it's a little bit more of a sophisticated kind of situation, but we kind of are all familiar with that term of negative amortization, right? So more often than not, we're not seeing a neg-am sort of seller financing situation. If we get into that situation, then we can walk through it. But because it's so rare, I don't really want to talk about it too much. Paragraph 15, same thing, an all-inclusive deed of trust. All right, some call it that wraparound, and you'll see in the parentheses there where it says this transaction involves the use of an all-inclusive or wraparound deed of trust. All right, we don't see that too often in our run-of-the-mill kind of deals where we're involved with. If your client is talking about having a wraparound or all-inclusive deed of trust, let's talk, because they're probably going to need an attorney to help them with that. That's not something that our escrow companies like to get involved in, like just the standard note and deed of trust. Okay, so the AITD is not something that we should probably be doing without the parties having some legal advice. Okay, because there are some ramifications to the AITD sort of process. It's more like a subject to sort of financing.
Mike, is that similar to like a deed in lieu of foreclosure, or?
No, so a deed in lieu is totally different. So a deed in lieu of foreclosure would be where there is a foreclosure action, and rather than the trustee who has the authority under the deed of trust to sell, that's why it's called a trustee sale, right? They have the authority to actually sell it at the trustee's sale. Instead of that going to sale, the seller said, or the owner says, I'll just give you I'll transfer the property back to you in lieu of foreclosure. So that's the deed in lieu of foreclosure. So rather than it going to actual sale via foreclosure action, the buyer or the owner just says, I'll transfer the property back. Lender, you're now the owner of the property. That's a deed in lieu of foreclosure. Okay. The AITD is a transfer of the property. There's usually two deeds of trust. It's like a subject to financing, but it's all inclusive because they're wrapping both deeds of trust, okay, into one. So you typically, and there are some really interesting things that can come up with it, but I don't want to get into it because it takes us kind of down a rabbit hole. I had a case one time with an AITD, and it was really, really interesting the way that the law kind of treats that stuff, but I don't want to get into it too much. Tax ID numbers, paragraph 16 is already checked, right? So they got to exchange this information, social security numbers, taxpayer identification numbers. That's pretty standard stuff. We're going to see that with financing. Paragraph 17, other credit terms, conditions, and addenda. Usually we don't see too much being added here, but just know that you do have the ability to add a few other terms if you need to. Paragraph 18, recording. Okay, so we're always going to check this box. The documents evidencing credit, back to paragraph 3, which is the note and deed of trust that we were talking about, will be recorded with the county recorder where the property is located, and recording fees paid for by buyer, or you can check the box seller. If not, buyer and seller advise that the respective interest in the property may be jeopardized by intervening liens, judgments, encumbrances, or subsequent transfers. So really all that means is, hey, we're going to record the deed of trust. Okay, so we want to check that box. Again, totally standard stuff, right? But we definitely want the deed of trust recorded because that is what protects the seller's interest. Okay. If we're doing this through our escrow companies, of course, it all gets recorded with the transfer and everything. Okay. Junior financing, there will be additional financing secured by the property junior to the seller financing, and then it says explain. So this is where, for whatever reason, rather than the seller financing being the junior loan, the seller financing is going to be either in first or second position, but then there's going to be another loan that's going to be junior to the seller financing. Okay.
Give an example.
Give an example?
Meaning, like in this situation, who would be a junior financer to the seller
Maybe,
financing?
I'm trying to think.
Mom
So
and
maybe,
dad.
yeah, I was going to say hard money. So maybe the seller carries back, and then, yeah, and mom and dad is a great example. So let's go back to our example where we said mom and dad gave the kids $100,000 to buy the property, and it's not a gift. They're actually loaning it to them, and you have seller financing. And again, this is unusual. You would have to have some pretty specific facts. But let's say the seller's carrying back $500,000, and kids only, let's just $1 million. Kids had $300,000 but needed another $2. So the seller's going to carry $5. Mom and dad are going to loan them $200,000, right? With the kids bringing in another $3. Mom and dad would be junior, may have a note, may want it secured by a deed of trust. We've actually seen this happen. Or they may say, yeah, I want that deed of trust, but I'm not going to record it. But if they want their interest protected, they'll record that deed of trust in a junior position. Okay. So that's an
Actual
example.
lender would not allow that to happen.
No.
Probably would not do that.
Probably not.
Even if they were.
Well, I think it all depends on the facts. I don't want to say no, but that's just an example.
Yeah.
Okay, so maybe mom and dad did give some money and they want to be secured.
Thanks.
Okay, senior loans and encumbrances. So paragraph 20, the following information is provided on loans and or encumbrances that will be senior to seller financing. So here's the situation with the opposite, where the seller financing will be junior financing, which we've talked a little bit about already. And then they want to know the information of the senior lien holder's loan. Okay, so you would complete that if you're going to have a senior lien on the property. All right, that way the seller, who's going to be carrying back the second, just knows everything that's going on with that senior loan. Okay? And then paragraph 21 at the bottom, buyer's creditworthiness. Okay, it says in addition to the loan application, credit report, and other information requested under paragraph 2, you can either say no other disclosure concerning buyer's creditworthiness has been made to seller, or you can make the following representations if you need to on the form itself. I've seen it go both ways. Okay, I've seen it where a seller's like, I'm good with the loan application, I'm good with their credit report, I've already received, some of this stuff, their bank account statements, their income, so they don't need to fill anything else out. Okay, then I've seen where we have filled it out just because the facts called for providing a little bit more information to the seller. Okay, so it's really just dependent on that specific situation. Okay, and then real quickly, paragraph 22, added, deleted, or substituted buyers. We know our contract allows us to assign it to new buyers or add a buyer within a certain time frame, things like that. When you have seller financing, you're going to have to get the seller's approval. Okay, our contract says basically that it can be assigned with the seller's consent, which can't be unreasonably withheld, something of that nature. Here, now because the seller is going to be a lender, it says the seller may grant or withhold consent in seller's sole discretion. All right? Because they're also going to be the lender on the property. So they're not just the seller, but they're going to continue to have an interest in the property post-closing as a lender. So now they have more discretion over whether or not they allow you to start switching buyers around and things like that. Okay, which makes sense. What's that?
If they were to refinance, it wouldn't affect the junior one, right?
It depends on the refinance. So let's say, and that's not uncommon either, for the seller to carry back and then at some point down the road for them to refinance and pay off the seller. If there are two loans on the property, typically they're going to have to the seller's going to know about it as a junior lien holder if the refinance is not paying off the seller, because the seller's going to have to agree to then subordinate to the first again, because the way that the lien positions are governed by what's recorded, right, as far as chronologically. So the seller would actually, if they don't get a subordination agreement, would jump to first position when that refinance gets recorded. So they typically would go to the seller and say, hey, we were going to refinance, we're only going to refinance the first. Will you agree to subordinate to that first when we refi?
Mike, if you're in the junior position and the first lender is in foreclosing, a lot of the times you'll show up at the auction to protect your interest.
Mm-hmm.
Is there a mechanism where you can just say, hey, listen, kick that guy out and I'll take over the loan, and then that way additional fees and are not brought, accumulated? So that
when you say kick that guy out, what do you mean by that?
Okay,
Just so I'm clear who you're talking about.
You've got a first lien. You're the seller.
Yep.
You're the junior lien holder, and the first lien holder files a notice of default and eventually to foreclose on the property.
Yeah.
Is there a mechanism as a junior holder to cut to the chase and just say, listen, I'll take the first lien holder out, so that, because whenever you have a foreclosure, there's a ton of expenses, lawyers' fees, a lot of other things that accumulate, and now your position that might have been comfortable just had $100,000 or $200,000 worth of fees added onto it because of the foreclosure.
Yeah, I mean, you can either bring it current, start paying it, but you can't just have that seller just transfer title to you, for example.
I'm talking about the lien holder.
You could
Say if you're the junior.
take their position.
Yeah.
Yeah, you're going to have to pay them. You could go to the auction. Let's say, again, let's just play a number, $600,000, and you have $200,000 in second financing, and the first goes to foreclose, and they're still owed $550,000. Just picking a number. You can go and pay that off, and take over their position, okay? And then you're obviously your position is just what their position was at that point. So that's why if you get the request for notice of default, you can show up and you can, or not show up, but even just pay it off for them. You'll jump into first position. But you want to do that in conjunction with getting title to the property, obviously. So now you're the owner.
But is there a way to avoid all the fees that are going to go along with that going to auction, or is it just?
I don't think so. So is there a way to avoid all those fees going to auction and just? The problem is, like I said, you can either bring it current to protect your interest, but you don't have a title to the property. I don't think there is, Rich, but I don't know for sure, to be honest with you, because I think that they're going to have to show up and basically buy out their position as part of the sale, because otherwise they're not going to have title. They've just secured their interest by bringing that loan current.
Right.
So. Yeah, and I'm just kind of thinking through those days when that was popular and what all that looked like. So that's basically the SFA. Again, there's some other cautions here. All of this stuff will be taken care of for you, like in the deed of trust, like the balloon payment in paragraph A. There's a certain notice requirement that has to go in the deed of trust. That gets taken care of by escrow. Those sorts of deeds of trust are pretty well understood by our escrow companies. Okay. Any kind of, I guess, last questions on this? Yes, Rayanne.
So who's generating these documents? Is it
The
generated with the RPA at the time of?
So it depends, and that's why I said it could have been an addendum to the original purchase agreement. It could be an addendum to the counteroffer. It could be introduced as an addendum in the middle of the transaction, where parties are working through it, and all of a sudden they're trying to keep the deal together, and the seller's like, "Hey, I don't want to lose these buyers. I'll carry back paper," and then they put this and they add it to the agreement as an addendum. But it is an addendum to the purchase agreement, and it gets turned over to escrow. Then escrow takes this and drafts your note and deed of trust.
So this could even come after, during escrow?
It could come during escrow. Yeah, it could come. Maybe the parties weren't thinking about it, and the deal looks like it's falling apart, and this is one way to perhaps save it.
Okay.
Yeah, it could come. It could come in the middle of the transaction.
So
Either side can generate it, 100%. Either side can generate it.
Take a lot of communication.
It takes a lot of communication, and it takes a lot of understanding by the parties, especially the seller, obviously, because they're the ones that are going to continue to have an interest in the property after close of escrow.
How common is it?
This, not super common, but I mean, we've already had a couple of them come up this year. Every year, I mean, from just what I see, and I mean, I don't see all of them, I probably see 10 to 15, which is not that uncommon. Like at least exploring it. Sometimes, like when we were talking about the option agreement, we'll start exploring it and then maybe we don't need it or something. But yeah, I've seen a number of them this year already. A number of them have come up. And I bring it up now just because as the market shifts and things sit on the market longer and there's all this equity that's available with sellers, it may not be out of the question that we start to see these more again, where we weren't seeing them for 2 years.
If they do an appraisal and it's short, like 50,000, but it's like, hey, this is my dream home, I just don't have any other way
To cover that gap?
Exactly.
Could be, yeah, as long as it doesn't affect their qualifying of their loan at all. Yeah, that's why I say still got to always fit into that if there's going to be a first on the property. Yeah, and then the seller look at it and say, okay, I'm going to be in a junior position for $50,000, but I still have another $300,000 in equity. So even if the market corrects a little bit and depreciates slightly, I'm still going to be plenty secure because the first is only X, mine plus the first is only X, and there's still $200,000 in equity. So in other words, seller's not going to walk away from the property because they have too much equity. Something really goes sideways for the seller, they're going to sell the property, and I'm still going to get paid, right? That was like the whole financial crisis. That was the issue, is that we were at 100% finance. One of the issues, 100% financing. You're upside down 30%. Where's the incentive for the seller to do anything but walk away from the property?
But it's coming back, baby.
I mean, I don't know. All right, let's go to the next form real quick. I'm just going to go through this one quickly. And then I'm not going to go through the last form because it's exactly the same. I just included it. So keep scrolling, Ty. Sorry, those are just notes to the SFA. So seller's intent to exchange addendum. I don't see this a lot in 1031s, and it's a really good form. So I wanted to bring it up for 1031 exchanges, and I'm just going to spend about 5 to 10 minutes on it, and we'll wrap it up. So there's a seller's intent and buyer's intent to exchange. And the buyer's intent is exactly the same, so we're not going to go through it today. I just wanted you to have it. So it's paragraph 1, seller's intent to exchange. The reason I like this form is because it gives our seller different options. And when we're in a low inventory sort of environment and somebody's trying to do a 1031 exchange, we know there are certain time frames. And this gives sellers more flexibility. All right, so I at least want you to be aware of it so we don't get our sellers into a position where they're struggling to find that replacement property and they're up against the time frame. So seller's intent to exchange. It is the intent of the seller to utilize this transaction as part of an exchange of like-kind property under Internal Revenue Code Section 1031 and the regulations promulgated thereunder. So there's the disclosure that we're always making, right? Hey, the seller's intending to exchange this property for another property. We now have that language right here in the addendum. And then the other property. So the other property to be exchanged is described as blank. So if you've already identified, you can go ahead and put the property interest or property address in there, or you can check the box right here to be located and designated. So you're, again, now you're telling the buyer, hey, we haven't identified yet. We're working on it. We're going to be telling you. All right. So we're telling them we're going to exchange. We're telling them we have or have not yet located the property. And now we're talking about, we have this cooperation language, which we throw into a lot of contracts. And we kind of like, I don't know, half-ass the language a little bit, for lack of a better term. Like it's not always laid out well. We're just saying like, hey, buyer agrees to cooperate with the seller's 1031 exchange. Now we have that language much better drafted here. So buyer in this transaction should not be required to take title to other property for any period of time as an accommodation to seller, unless agreed in writing. Buyer agrees to take such actions and execute or consent to such additional documents and transactions as may be reasonably requested by seller, provided that all other conditions in the agreement are met. So basically, we may need the buyer's cooperation, okay, with the 1031, but it's not going to have any negative impact on the buyer, okay? But we want you to know we're doing one, and there may be a couple of documents you may need to sign if we're assigning this to the accommodator or something like that. So you're going to cooperate with us, but it's not going to have any negative impact. It's not going to cost you any money. None of that, but we may need some cooperation.
And that cooperation is asking the buyer to potentially delay taking title so the seller can work within their 45-day identification of their next property.
That's it. That section right there is not asking the buyer to delay taking title.
Okay, that's what I heard. Okay.
No, it says buyer in this transaction shall not be required to take title to other property. In other words, they're not going to have to take title for any reason to the property that's being identified as the replacement property. They're not going to have to do any of that, okay? Where we talk about delays in the close of this transaction is paragraph 4. One of the reasons I like this form is paragraph 4. It gives our sellers just a little bit of flexibility, or no flexibility, depending on what we choose, but we have the option to create some flexibility for the seller. So it says failure of exchange. If seller is unable, through no fault of seller, to locate, designate, enter into a contract to acquire, or complete an acquisition of such other property by the close of escrow of the agreement, or is extended by mutual agreement, you now have 4 options. One is, this transaction shall close without extension of time for closing. So in other words, nothing happens. You still got to close the deal, seller, okay? Even though you haven't been able to identify, or maybe you did identify and that transaction fell through, too bad, you still need to close this transaction on the scheduled close of escrow date. Okay? Or we can create a little bit of flexibility here with section B or C. So the close of escrow for this transaction shall be extended by a maximum of blank days to enable seller to complete such arrangements. So if we haven't identified and we know that we only have 45 days to identify after close, and the seller's like, ooh, I don't know, I'm looking out there, I need more time, I'm not comfortable with closing yet. If we have this form a part of our contract and we have, I don't know, let's pick a day, 30 days, it's going to give the seller the option to extend the close of escrow to give them more time to locate a replacement property. Just a little bit more, and we've seen that in this market, right? Where the inventory is just not as substantial as maybe it's been in the past. And sellers a little bit concerned about having only 45 days to find a replacement property after close. Or C, the transaction shall be canceled, buyer's deposit shall be returned to buyer, and all parties shall be released from any further obligation to each other. We have used this form with C checked in a situation where our seller could not. They've really tried to find a replacement property, could not do it, or they found one and it fell out, and they canceled the deal. So it's almost like a seller contingency, okay, for like the purchase of a replacement property. And then I haven't really seen a whole lot done with the other paragraph. These are the two that we typically see, if anything, And kind of that middle road is just, hey, give me more time. With the one that really protects the seller more is just, I'm going to cancel the deal if I can't find a replacement property. Okay, so that's where I say it gives the seller more flexibility. Right? If we don't have this attached, okay, and we just have some boilerplate cooperation language, buyer agrees to cooperate in the 1031 exchange, and our seller is struggling to find a replacement property because they haven't located one yet, we got to close. There's nothing that allows the seller to get out. Does that make sense? Okay, so this form is not used a ton in my experience. Agents that I've talked to when they're doing a 1031, I encourage them to use it because I think it is a good form. It has all the boilerplate language that we like to see in our RPA for 1031s, plus it gives us some flexibility. And this is usually being incorporated via a counteroffer from the seller, okay? And it's really transparent. It lets the buyer know right up front what's going on, and it gives the seller that flexibility that in this market could be really important for them, especially if they haven't yet located that replacement property, okay? Or they're concerned about, maybe they're in the transaction, they're a little concerned about it or something, all right? And then paragraph 5, 6, and 7 is pretty boilerplate. I'm not going to go through it. It's just
Actually, Mike, on that,
boilerplate language. Yeah.
on paragraph 5 where it says seller shall indemnify, that protects the seller. But if you're a buyer and you did a phase 1, or you're doing you're doing inspections and other things, you've put money out. So how come the buyer's not being protected?
It actually doesn't protect the seller. Say seller shall indemnify, defend, and hold harmless the other party to this transaction and agents from all liabilities and any additional attorney's fees, accountant fees, or any other costs arising from or connected in any way with the exchange. So it's the seller indemnifying the buyer and other parties, but it's very limited to the exchange. If the buyer, and this is why I suggest using the form, to your point, Rich, you said, hey, commercial, you're doing a phase 1, phase 2, which is even more expensive, you're putting out all these costs, and then all of a sudden the seller goes, oh, I don't think I could find a replacement property, and they start looking for a way out of the deal. Yeah, that you could have spent $40,000 from the buyer. Here, if this form is there, that buyer knows right up front with the offer stage, this is what's going to happen in paragraph 4 if I cannot locate a replacement property. I'm either going to ask for an extension to the close of escrow, I'm going to do nothing, I'm just going to close the deal, at least the buyer knows, or guess what, I have a cancel option here. I have the right to cancel the contract. Now, if you're the buyer and you see that, maybe you change your offer. You put in terms that, hey, if the buyer will be entitled to reimbursement of costs up to X number of dollars if the seller exercises their option to cancel in 4C or something. At least the buyer knows up front, and we can start to negotiate that or address it up front, as opposed to getting in the middle of the transaction and all of a sudden things start falling apart and it gets really ugly really fast.
I was thinking another option would be if you have to extend the close of escrow by 30 days, do essentially like a rent back, but it's before close of escrow. So that extra 30 days, you're going to pay the buyer whatever amount for the month just to buy yourself more time, so the buyer isn't.
Yeah, I mean, so Dorinda's point could be, if paragraph 4B is in there, well, maybe that extension comes at a cost for the seller.
We'll give you, the cost will
It doesn't state that anywhere,
No,
but maybe it could be another. It could be a buyer counteroffer where it's saying, okay, I'm agreeing these terms. If buyer exercises their right to extend the close of escrow at 30 days, it shall be, at
the cost of $5,000 or whatever.
Yeah, there could be a cost associated with it. It could be, like I said, if there's a cancellation right, maybe the seller has to reimburse the buyer for out-of-pocket costs for inspections, et cetera, et cetera. But the form, again, the big picture of why I want you guys to take a look at it is it allows for all those things we're discussing. Whereas if we have the one sentence, buyer agrees to cooperate with seller's 1031 exchange, and our other terms of the RPA, well, what happens in these scenarios? Okay. I had a question. What is like-kind property? So like-kind property, when we're talking about 1031s, is not commercial for commercial, multifamily for multifamily. It's basically for income producing. Okay, so it's very broad. is very broad. So if you can exchange a duplex into a retail center. You can exchange a 5-unit building into industrial. Income for income is really what like-kind
You could
is.
even exchange it for REITs.
Yeah, you can. So it's pretty broad. It's pretty broad.
What can't you do?
You can't go. Well, you can't go. You can't go like duplex into your primary home. That's not like for like. Okay, that's kind of the one we see. There's some ownership requirements. I don't want to get into all of that, but you have to kind of have the same ownership requirements. Okay, so but like for like is, think of it as very broad, income for income, for the most part. Okay, so it's pretty broad. Oh, 100%. Yeah, 1031 is IRS, federal. You can go from any state to any state. Yep, it's not just California. Yeah. Okay. Any questions? Just because we're up against the hour. Any questions on this? Just again, if you're doing a 1031, really consider this form as part of your package. I think it's pretty well drafted, and it gives our sellers. And the buy form is exactly the same thing. It creates a contingency for the buyer, things like that, if they're doing a 1031. So, all right. I don't think I had it. Let me just make sure I didn't have any other questions real quick. That was the only question. Okay. All right. Any other questions? All right. Perfect. Thanks, guys. You're welcome.